So my section is about pets, and then Mark's going to be talking about smoking. So probably the two most popular topics in body corporate world. I know everybody on the call's probably dealt with these things many a time in the past, and there's been recent changes on both of these fronts. So that's what we're covering off tonight. So I'll share my screen and you can have a look at my slides. Okay, so I think everybody should be able to see that now, and we'll get going. So the first topic tonight is new pet rules for tenants in Queensland. This will have an impact on all ranges of people in body corporate world, and in fact outside of bodies corporate as well, in the general rental market of houses, but it has a particular impact for body corporate communities because there are multiple levels of approval required and regulation for pets in apartment buildings and townhouses. So what's changed? There's been an update to the Rental Tenancies and Rooming Accommodation Act. So that's the legislation that governs the way that tenants and property owners or landlords work together, and it is where tenants' rights are documented effectively. So anyone who's been a rental owner before or a tenant would know about the RTA. That is a body that's called up in this legislation, and it administers these rules. So this legislation change is a fairly major change. It's come in over several waves, so different rules have come in at different times. So the legislation that's coming in this October does change the way that pets work in rental properties. So the major change is the way that landlords deal with pet applications from their tenants. So the impact of the new legislation is that landlords will be unable to apply a blanket ban on pets within their rental property. So previously it was totally up to the landlord about whether they accepted pets in their rental property or not. That was just a landlord decision, and tenants had to respect the landlord's decision. If they wanted a pet and the landlord said no, they would typically move to a different property that was more pet friendly. That is now changing, and we'll get into that in a minute. There will also be a specific form from the RTA for a tenant to apply to keep a pet that hasn't existed previously, but will become a form and a streamlined process for tenants to use. Landlords will now need to consider all pet applications based on their own individual merits. So you can't have a blanket ban at the landlord level anymore. Landlords are now being treated like a body corporate, where you've got to actually look at the application and make a merit-based decision based on the substance of each application, what the person's like, what the pet's like, and what exactly they're proposing. A big issue that we'll cover is the landlord in any rental property, if they receive an application from the tenant, must give the tenant an answer within 14 days of receiving the application. If the landlord doesn't respond, then the law considers that the pet has been approved. So if you don't get an answer back from your landlord, you're deemed to have received approval. So that makes it a really streamlined process for tenants to get approvals from landlords. And it's something that, because it's a totally new policy, a lot of landlords will be caught off guard, potentially not get an answer back to the tenant quickly enough, and then the tenant effectively has a blank check to come and keep their pet in the lot. Applications for keeping pets can only be refused by the landlord based on a specific list of prescribed grounds. So it can't just be that you don't like Dalmatians because of their spots. You've got to have a specific reason, and it's based on a list of reasons that are set out in the legislation. What are those reasons? So a lot of these are just common sense. Some of them, common sense isn't necessarily all that common. So there's a few easy ones. So for example, the landlord can refuse if the premises is unsuitable for keeping a pet because of fencing, open space, or something needed to humanely accommodate the pet. The pet has to be an actual pet, so it doesn't apply to things like horses and cows. It has to be a domestic pet. The number 6 of the prescribed reasons for refusing a pet is the most important for tonight. So the landlord may refuse a pet if keeping that pet would contravene a body corporate bylaw applying to the premises. So if there's a body corporate bylaw that means the pet can't live in the body corporate community, that is a good enough reason for the landlord to refuse that pet application from their tenant. That causes, of course, a tension between what the body corporate bylaws say and what the landlord has to say to the tenant. So importantly, bylaws overrule the right of a tenant under that residential tenancy legislation. So whilst body corporate outright bans on pets are not common, and we've discussed previously that those are typically unlawful, most buildings or most body corporate have some type of restriction or regulation on the type and the number of pets that a resident can have in the building. So those are generally something like a requirement to obtain committee approval for each pet, a requirement to register the pet with the on-site manager or caretaker or body corporate manager. Often will restrict the number of pets and the type of pets and give conditions about how the pet needs to live at the site, where it can go, where it can't go, and that it's not allowed to bite people and all those sorts of conditions that you see on pet applications. So if a tenancy application comes in and it is inconsistent with a bylaw that is existing at the property, then the body corporate bylaw will overrule the tenant application, and the landlord will need to say to the tenant, look, you can't have a pet at this particular building because you've requested 4 cats, and the body corporate bylaws say that you're only allowed to have 1 cat and 1 dog, for example. Here are some examples. So if a tenant applies and receives approval from their lot owner, from the landlord, to keep a second pet, but the body corporate bylaws only allow 1 pet per lot, then the tenant would be in breach of the bylaws, and the landlord would need to say no to that tenant when they receive the application. In the second example, if the body corporate bylaws require committee approval for residents to keep a pet and the tenant only gets approval from the landlord but not from the committee, then the tenant would be in breach of the bylaws and would need to remove the pet until they receive the body corporate approval. So you can see this is already getting way more complicated than it used to be, which is why we're talking about it. What the committee needs to do about this, or should do about it, is a couple of things. Number 1 is ensure that you've got a copy of the community management statement, the CMS, which includes all the current bylaws. You can confirm what that looks like with our team if you're unsure, but I'll put some examples up. If your building has a bylaw that requires committee approval for pets, then have that application form ready to go. So if you're asked, you know how to refer people to get the right answer. BCsystems clients have a form which is linked, it's on our website, and most other body corporate managers will have a similar form to allow people to make applications to the committee online. Understand and advise owners and tenants about the decision timeframes. The landlord needs to provide an answer within 14 days to their tenant, but the body corporate committee has up to 6 weeks to consider pet applications at a body corporate level. So there's a massive inconsistency in time frame expectations there, and that would need to be proactively dealt with, otherwise disputes will inevitably arise from that. Finding the correct bylaws. So the CMS, the community management statement, is like the constitution of the body corporate. It's got the body corporate's name, a list of all of the lots and plan numbers, a list of the lot entitlements, the bylaws and any exclusive use areas, and a few other things. And this is a little screenshot of what the front page of that typically looks like. It will have a big sticker and a dealing number from the land titles office on the front. The inside pages look something like this. There'll be a version of this, and this is sort of just how you know that you're looking generally at the right document. Of course, each one will be different. If you've got for your body corporate a document that looks something like on this slide, then, or if it just says bylaws on the top and it doesn't have all of the other things I just showed you, this is probably not the correct bylaws for your body corporate scheme. These might be things downloaded from the website of the Commissioner's Office or pulled out of the legislation, which are often templates or default bylaws, and it's very rare that a building would actually be using these as shown. So it is important to find your own body corporate bylaws, not just something that says bylaws on it. This is, can be complicated. So it's something to ask your body corporate manager about if you're unsure whether you've got the right document or not. Some common types of pet bylaws. First one is no pet bylaw at all. So some bylaws just don't mention pets or animals. They just don't mention them at all. So if something's not in the bylaws at all, then that rule just does not exist. So if the bylaws are silent on pets, then there's no specific restriction from the body corporate on pets in that complex. If you had a pet in there and it was barking, the body corporate might need to use a noise bylaw to address that. It wouldn't be able to use a pet bylaw if there is no pet bylaw. The other general type is a permissive bylaw. So this is where the bylaw just gives approval sort of in advance. So where it might say an occupier may keep one dog or one cat within the lot, and it must not go in the pool area and must not cause a nuisance to others. I've just sort of made that up and paraphrased it, but that's the type of bylaw that you sometimes see where the approval is already given with some conditions. And the other type, the most common type, is a restrictive bylaw. So this is where an occupier must not keep a pet unless they get written approval from the body corporate in advance. This is the type of bylaw that requires people to come and get approval for each and every pet in the building, and that causes the slowdown and the reason why the committee has to look at all these applications and make decisions on each one. I should say, I forget to mention this at the start, but if you've got a question at any time, just pop it in the Q&A box in the Teams interface, and then we can come back and answer it at the end, and that goes for both me and for Mark. Or we can unmute people and you can ask your question at the end, but if you pop it in the chat box, it'll stop you from forgetting. Okay, so inconsistency in the decision time frame. This will cause a lot of problems. It's important that we just know about it so we can try and manage it as carefully as we can, working with the committee and on-site manager and body corporate manager. So the rental owner or the landlord has to give an answer to the tenant within 14 days of receiving the application. The body corporate has to give their answer within 6 to 9 weeks, depending on when their meeting happens to be or if there is a meeting called at all. So that means the tenant will get an answer from the owner much earlier than they hear from the body corporate. And the owner's answer will mostly need to be conditional on also getting body corporate approval. As everybody I'm sure knows, pets are often very emotionally charged issues for people, and tenants will generally expect an answer more quickly than 6 to 9 weeks, and usually are looking for a yes answer rather than a no answer. That doesn't mean the body corporate can't say no, but it just will indicate the level of tension that can exist between the tenant, the owner, the property manager, and the committee in this dynamic. The other thing that we'll see is a lot of pressure put on committees to make decisions quickly so that tenants can sign leases and move in, and owners won't be happy if they've got a tenant who misses out on the property or goes and rents somewhere else because the committee was too slow in making a decision. So the committee does have that amount of time so that it can make good decisions, but there will be a lot of pressure from tenants and from rental property managers to make decisions more quickly. So some of the issues that we anticipate seeing, as we talked about, under the law, the owner's approval or deemed approval if they don't respond is not valid. It's void if the body corporate bylaws are breached by that approval. The challenge is that regardless of the status of whether the bylaws are allowed or not, most tenants will just bring the pet into the property immediately after getting an answer from the owner. So that's probably the most likely scenario. If you apply for, if you're a tenant, you apply to your real estate agent for a pet, and 14 days later you get a yes, but, or you get silence, you're probably going to just bring the pet in or buy the pet, from a breeder. That will then put the body corporate on the back foot, where it still has its own process to follow, but the tenant has already brought the pet into the building with the owner's approval, but they haven't got the body corporate's approval yet. And then you're sort of in a stalemate. The body corporate must enforce bylaw breaches against the tenant. So if someone breaches the bylaws, the body corporate can't just ignore it. It must either enforce the bylaw, or if it thinks the bylaw should not be enforced, it should take the bylaw out of the bylaws. And the owner or the agent would also be required to enforce a tenancy breach against the tenant, because if the tenant's got a pet in the scheme and it doesn't have body corporate approval, then that's automatically a breach of their lease as well. So that creates a situation where everybody's now in a dispute, and the pet is probably going to be already living in the lot happily. The pet probably won't know these disputes are happening. And it means that the body corporate will not be starting from a position of strength. Body corporate, of course, can say no to pet applications. The committee has to make a decision on each application based on its own merits, similar to how a landlord operates. If the body corporate declines a pet approval, then the pet is not approved and it can't come into the body corporate. It doesn't matter what the landlord says. If the body corporate has a right to say no, and it does say no for a reasonable reason, then that's the decision. The committee does not need to give written reasons for its decision, and generally does not do that unless it goes to a dispute. There is a right that tenants and owners have to appeal a body corporate committee decision, but that process is quite slow. Most tenants are not going to be prepared to wait 4 to 6 months for an appeal outcome if they've already got the pet, if the pet's living with a friend, or if the pet's living in the building. It's just not likely to result in a lot of these applications, I don't think, because it'll either get brought to a head much more quickly in a dispute between the owner and the tenant, or the tenant will just keep the pet in the building, dig their heels in, and it will be up to the body corporate to then do something about it. One of the main drivers of these challenges will be the media coverage. So every tenant in Queensland is likely to know about these new rights if they don't already know. So there's been lots of articles, Brisbane Times and the ABC and Courier Mail about new rights for tenants. It's something that's quite popular to talk about and gets a lot of activity on social media and on the web. So every tenant's likely to know the rules. And the rules are the same for all tenants, whether you live in a house or an apartment building or a townhouse complex. It's easy to give a message when the message is consistent. The tenants in strata or body corporate properties are unlikely to know about their bylaws for that particular building. So bylaws are not discussed in any of the media coverage that we've read so far. It's been silent on the body corporate side of the discussion. And that probably makes sense, because whilst the tenant rights are consistent for all tenants, each building has its own bylaws. They can be quite different to one another. So it's much harder to give a consistent message out in the media, because it would have to be so generic and say, each person's circumstances will be different. So that means there's a lot of tenant positive communication out there, and not a lot of warnings or information aimed at committees. So this is again going to make this an uphill battle for bodies corporate and committees to try and defend the body corporate's rights, which is to regulate the scheme and to make good decisions about what pets can come in and can't come in and how they need to behave in the scheme. So just a bit of a summary and where we see this happening. I just said the tenancy laws and tenants' rights are the same, but every set of body corporate bylaws is unique. It's harder then to get information out to committees. You can't talk to the building next door because they may have different bylaws to you. So you be able to gain a little bit of benefit by sharing information, but you can't copy and paste things, between one building and the other because they are so different. The resources available to tenants and rental agents through the RTA is really strong and specific, and makes it quite easy for tenants to follow their own processes, where everything in body corporate land is often, harder than we think it should be because of the mechanics of getting, an elected group of people to make decisions on behalf of a much bigger group of owners, and all of the democratic issues that can come from that. The big takeaway is that at the moment, a lot of pets are currently blocked from entering the building because of the landlord's personal pet preferences for their own unit. So if you've got a building with 100 rental properties in it, maybe only 10 of those or 20 of those landlords allow pets at the moment. So the committee is currently getting applications from 20% of the available rental units. Whereas under the new rules, every single tenant will be able to make applications and get those through to the committee, no matter what the landlord's preferences are. So depending on how many rentals are in your building, you may find you get way more tenant pet applications after October than you did in September. Media attention will also heighten the impact for bodies corporate. Pets are really popular. There was a big spike in people having pets after COVID and spending more time at home, working from home. It's made pet ownership a lot easier for a lot more people. So the number of pet applications already was on the rise in the last 2 years, and I think will just continue to surge through these new pet rights. And that's probably, that will be the reason that these pet rights were even considered, is because pet ownership is increasing and people like having pets at home. Even when the rental property manager or the owner gives a copy of the bylaws to the tenant in advance, tenants rarely review the body corporate bylaws in detail before they sign the lease. Most people get approved, they're happy, they sign the lease straight away, and then they're not necessarily considering whether the bylaws restrict their pet rights. That means arguments are likely to happen when the pet's already living there instead of before it moves in. One of the big recommendations, I suppose, from our side is that committees who currently tick and flick pet applications, which, honestly is most committees, those committees may choose to streamline their own body corporate bylaws so that the pet approval is one of those permissive types where the pet is automatically approved with conditions, rather than each pet needing to have its own decision of the committee with a full application process. So that, there's plenty of committees out there who are dealing with, 5 or 10 pet applications a month, every month, and it's a heap of workload. And most of those committees are doing it because the bylaw structure is so that they have to. But you might find that you have the same overall effect if you have a strong bylaw that sets expectations but doesn't require a full process for every single pet application. And when I say tick and flick, I don't mean that in a negative way, but if you don't know anything about that specific pet other than its name is Roger and it's a dog, well, you're probably going to just vote yes to that application with conditions, and your plan is to use the conditions if that pet causes a problem in the future. So that might be a way that the committee can mitigate some of these impacts by reducing the amount of friction between the tenant and the building or the body corporate. And that way, the committee has to do less work, the applications go through more quickly, and that decision, if it's supported by a majority of owners, should, you know, go down relatively well with most owners in the building, because they would be in a position to vote for that change as well. So that's something, you know, we're always prepared to continue working with our committees to achieve the best outcome for their individual building. Of course, every building's different, each committee is different, and the needs and the desires of each building is very different from one another. So what suits one won't necessarily suit the other, but this is an inflection point in the way pets are managed, and it's definitely worthwhile renewing these conversations and looking at pet bylaws, possibly for the first time since the building was built, to make sure that they still are the most appropriate solution for your individual needs. If you've got any questions about that, pop them in the Q&A. Otherwise, I'll be around at the end, and my contact details are on the screen. We'll send the slides around to everybody after the session as well. And then that's the end of my presentation. I will hand over now to Mark Mellick of Active Law. So Mark, for those who haven't had an introduction before, has been working for Bodies Corporate. Mark's a solicitor for a very long time. I've been working with Mark just under 10 years, and I'm sure he's been working for BCsystems clients for a lot longer than that. And so I'm sure you've probably seen his name before in a quote, or he's done some work for your building. And Mark's here to talk about smoking and, you know, on a similar tact about bylaws and how to manage these issues. So I'll hand over to you, Mark.
So firstly, I'd like to thank Matthew and BCsystems for inviting me to present this evening. Matthew mentioned before about, you know, pets being an issue. I've said historically over the years there's been the 3 Ps, which is pets, parking and parties. I certainly think that we can now add an S to the 3 Ps, and that is smoking. Not often, in my experience, have Bodies Corporate found their way into the media for a particular reason, but certainly you may all be aware of a decision called Artique, which related to smoking, and that was a decision of an adjudicator, and that certainly found its way into the Gold Coast Bulletin, and I believe it may have also got some mention in the Courier Mail. Now, smoking is becoming a big issue in society generally, and it's certainly an issue in body corporates. So the reason, why is it becoming an issue? It's becoming an issue because a significant amount of occupants are becoming or are subject to what we call smoke drift. So the Queensland Cancer Council of Queensland conducted a survey of smoke drift in multi-unit housing, and that survey suggested that up to 53% of residents in non-smoking units are exposed to second-hand smoke drift, and up to 25% of residents reported smoke drift daily or often. So it is simply a fact that smoke drift is impacting on residents' lives, and as Matthew touched on, how are community title schemes managed? They're managed through the bylaws, and we'll talk a bit later on about those specific bylaws, and certainly the bylaw that was in front of the adjudicator in the Artique decision. Now, there was a review of Strata law in New South Wales recently, and it was an all-encompassing review, and it came as somewhat as a surprise to me, because I expected the most common complaint to be to do with pets, which Matthew has just spoken about. But in fact, the most common complaint was smoke drift into non-smoking units. Now, that review, and this is critical to consider and critical to take in when we're talking about the Artique decision, but that review found that there is simply no safe level of exposure to secondhand smoke. So, arguably, according to the medicos, 5 minutes of secondhand smoke is dangerous to someone's health. Now, it won't come as a particular surprise to anyone all the medical effects that smoking has, and indeed secondhand smoke has. Now, I put some on there. I won't go through all of them. They're there for you to see, and as Matthew mentioned, the slides will be distributed to the participants and to anyone who wants them, in fact, at the conclusion of the presentation this evening. But I think it's important to note one of the boxes there, which the one that says as little as 30 minutes of exposure can affect blood and vascular function to almost the same extent as active smoking. And if we consider that for a moment, without wanting to dump on smokers, it certainly is something that needs to be properly regulated within the body corporate environment. Now, if we move to the ARTIC decision, which was a decision in 2021, and I have some familiarity with the ARTIC decision. It was in fact a bylaw that we had drafted here, so I was delighted that the bylaw stood up to the rigour of the adjudicator's office. I was sweating for a moment that it was going to be ruled invalid, but thankfully it wasn't. But putting in context the ARTIC decision, the respondent was a chain smoker and spent 5 minutes smoking a cigarette every 20 to 40 minutes. The allegation was by the applicant was that it was simply relentless and unbearable. I should put this in context that the respondent and the applicant had a lot of issues, but smoking was certainly the main issue. I think it's fair to say the respondent and applicant weren't the best of friends. Anyway, the applicant was concerned about smoke drift and its impact on her health. That's completely understandable, and argued that the smoke was interfering with her use and enjoyment of her lot, and particularly her balcony. She was continually closing doors to her balcony, but argued that was the only means of fresh air and that she felt suffocated and trapped. So it was having a significant impact on her amenity of life within the ARTIC community. Now, the adjudicator took note of the Tobacco and Other Smoking Products Act, which prohibited smoking in an enclosed place, including common areas of body corporates. Now, common areas includes areas that are accessible to all or a class of residents or employees. So, for example, if your body corporate has a gymnasium and people were smoking in there, irrespective of what your bylaws say, that is a breach of the Tobacco and Other Smoking Products Act. But of course, not all common areas will be necessarily enclosed or covered by restrictions within that legislation. For example, certainly within the ARTIC case, the balconies were on title and clearly not enclosed. So they weren't common property, they weren't enclosed. Now, there is no legislation in Queensland which expressly prohibits smoking within a community titled lot. And I get asked with regularity, will the day ever come where smoking will be banned within someone's lot? I must say, as a lawyer, it's hard for me to foresee that day coming. And I say that because there's a very ancient principle of law, and it's best summed up with a man's home is his castle. And I use the term man simply because that's how it's generally described. So it's very, very difficult for Parliament to legislate against what a person can do within their lot. I suspect it will certainly garner attention as the years go by, because the simple fact of the matter is, on the statistics, less and less people are smoking, which means that those people that are smoking, rightly or wrongly, are tending to be ostracised within the greater community. So it may be that down the track legislation does look at banning smoking within a lot. I don't think it will ever come to pass because, as I said, if you're smoking within a lot, there are other measures that one can take to necessarily prevent smoke drift. For example, by closing doors to the balcony so that all the smoke is contained within the lot, with the effect being that it's really only affecting the smoker and other people within that lot. Now, the bylaw that I mentioned earlier was, as I said, one that we drafted, and I've got it on the screen there for you. Look, there's no particular magic in the bylaw, but the important word for the context of the Article decision is the use of the word hazard. Now, an occupier must not cause a nuisance or a hazard or interfere unreasonably with the use and enjoyment of another lot, or interfere unreasonably with the use or enjoyment of the common property. Now, we then go on to say by smoking anywhere on the common property, importantly on the balcony of a lot, in circumstances where another person's enjoyment of their lot is unreasonably interfered with by smoke drift. Now, the use of the word hazard is important in the context of the RT decision, but the use of the word hazard was by no means a magical word by me, because it's words that are used in section 167 of the Body Corporate and Community Management Act, which is the nuisance provision. And that section refers to an owner or an occupier creating a nuisance or a hazard. So in essence, the bylaw, by and large, simply mirrors section 167 of the legislation. Now, the basis of the decision, and this is why I focused on the word hazard, was that in most of the previous cases, they were focused on the conduct constituting a nuisance rather than the conduct constituting a hazard. And there's a very, oldish now, 2010 decision, Norbury and Hogan, which really focused on nuisance. And the nuisance threshold, because of Norbury and Hogan, is particularly difficult, difficult threshold to reach. It imposes what is an objective test, and an objective test is a test that would be put forward by, for want of a better word, the general public. So that test is whether the volume or frequency of smoke permeating the lot would unreasonably interfere with the use and enjoyment of a lot by a person of ordinary sensitivity. So placing an ordinary person in the position of being on the receiving end of smoke drift, would that person be unreasonably interfered with? Will the use of their lot be unreasonably interfered with, judged by an ordinary everyday person? And the simple fact of the matter is, over the years, adjudicators and indeed often courts have not been satisfied that the conduct complained of, that is the second-hand smoke drift, constituted a nuisance or an unreasonable interference. There was a case in 2011, Admiralty Towers, and the applicant there included a register of smoke drifting into the lot. And it was a very detailed register. It was essentially a brief of evidence that was put to the adjudicator about how that applicant was affected by smoke drift, and the adjudicator found that it wasn't sufficient to be a nuisance or to have caused an unreasonable interference. There has been some successful decisions prior to RT, and I put one up there, which is Suncrest, a 2009 decision, where the adjudicator ordered the occupier of Lot 5 to take reasonable steps to ensure smoking cigarettes on Lot 2 or common property does not cause a nuisance to Mr. Hogan or interfere unreasonably with Mr. Hogan's use and enjoyment of Lot 5 in breach of section 167. So it wasn't in breach of a bylaw, it was in breach of 167. And importantly, in Suncrest, the adjudicator looked at it from the perspective of causing a nuisance or unreasonable interference. Again, the adjudicator did not look at it from the perspective of causing a hazard, and that is absolutely critical when we get to the RT decision, because what RT recognised was that the issue of whether smoking constitutes a hazard, contrary to section 167 of the Act, or indeed contrary to a bylaw, had not been specifically canvassed in Queensland. And I actually can't give you the reason why everybody up until the RT decision focused on a nuisance or an unreasonable interference. But what the adjudicator said in RT was that the harm from secondhand smoke is sufficiently widely accepted and evidenced that the applicant didn't even need to provide medical evidence to establish that there was harm. The adjudicator simply said there is a preponderance of evidence that secondhand smoke is a hazard, and therefore, irrespective of the fact, and therefore the applicant in that case didn't even need to put any evidence put forward, unlike, for example, in the Admiralty case that I mentioned previously, didn't need to put forward any evidence that she was suffering a hazard from this secondhand smoke drift, because in essence, it is widely known that secondhand smoke creates a hazard and is a risk of harm, and that the risk of harm is serious, is so serious that there does not appear to be a safe level of secondhand smoke exposure. Now, there's a couple of points of interest other than the ones that I've just mentioned that came out of the RT decision. When we were originally engaged, we weren't engaged in terms of preparing any submissions. The committee was of the view that it was a dispute between two lot owners and wasn't a matter for the body corporate. The adjudicator said that in essence, the body corporate had to become involved because it was a bylaw issue and there was a breach of the bylaw, and as Matthew mentioned earlier, the committee were under a statutory obligation to enforce bylaws. That is indeed correct. However, any decision a committee makes must be reasonable under section 94 of the Act. So enforcing a decision to enforce bylaws must also be a reasonable decision. And arguably, because there wasn't any evidence in the RT decision put forward by the applicant, the view could have been made, or the conclusion could have been reached, that based on the evidence put forward, there simply wasn't evidence supporting a breach of the bylaw. Therefore, it was unreasonable for the committee to enforce the bylaw. And now, I often use as a simpler explanation for that, if someone is parked in a visitor car, if an occupier is parked in a visitor car space for, say, 20 minutes while unloading their groceries, there are many adjudicators which have said, well, it would be unreasonable to enforce a bylaw which precluded occupants parking in visitor car spaces where they're only there for 20 minutes. So, yes, certainly it is the case that committee members are required and are obliged statutorily to enforce bylaws, but in doing so, they must be acting reasonably. Now, it's without contention that the body corporate did not issue a contravention notice in response to the applicant's complaints in RT. And the adjudicator said the body corporate is not obliged to enforce section 167 of the Act, but it does have a statutory obligation to enforce the bylaws, including bylaw 5. So I must say, yes, I agree, there's no obligation to enforce the statutory provisions in the legislation, certainly in regards to section 167 at least. But in RT, the adjudicator changed the landscape, in my view, a little bit, where it said, irrespective of the evidence, irrespective of the reasonableness of enforcing the bylaw, the body corporate committee is under a statutory obligation to enforce the bylaws. I tend to disagree with the adjudicator a little bit in that regard. Now, the adjudicator also commented the body corporate must act reasonably in undertaking its functions and in making decisions. That touches on what I just spoke about in regards to section 94. Now, and the adjudicator said if the body corporate did not reasonably believe that the respondent was in breach of bylaw 5, it did not need to issue a bylaw contravention notice to her, but essentially the adjudicator said there is no basis on which the body corporate could not reasonably have believed that bylaw 5 was being breached, and in fact said it could have asked the applicant for more evidence to assist in making the committee decision whether to enforce the bylaw or not. Now, importantly, and this I guess gets to the crux of what I was just saying, the adjudicator said, I do not consider that the body corporate could fail to act simply because it thought it was not its responsibility to decide if the bylaw had been breached or if it was just a matter between residents. And I think that really opens some issues for committees, particularly where there are warring occupants, where it really is a personal matter. It seems to me now that on the basis of the Artigue decision, committees need to simply jump in and enforce their bylaws, which could become quite costly for bodies corporate. Now, some other points of interest that I've included in the slide are the but where you've got public areas and community title schemes. So in playgrounds, for example, smoking is banned within 10 metres of a children's outdoor playground equipment situated at a place that is ordinarily open to the public, and there's an on-the-spot fine of $270. Entrances to buildings are regulated. So smoking within 5 metres of a non-residential building entrance, again, an on-the-spot fine of $270. Outdoor eating, of course, we all know that you can't, smoking in an outdoor area or drinking area is banned and carries a significant fine of $19,800. But you can smoke on a balcony immediately adjacent to someone else's balcony, to someone else's door, to someone else's window, and the onus is on the affected person to establish unreasonable interference, or that there's a nuisance, or that there's a hazard. And that seems to be a bit of a nonsense to me, because it is clear that governments both in Queensland, Australia and around the world have seen fit to regulate smoking within playgrounds, entrances to building, outdoor eating areas, and a myriad of other places. Yet, up until the Artigue decision, didn't see fit to regulate smoking within a community title scheme. So, moving forward, what impact does this have on bodies corporate? It seems to me now that as a result of Artigue, it will be relatively simple for an affected occupier to lodge applications and indeed be successful with applications, arguing that smoke drift from another's lot is creating a hazard. I suspect now people will simply not even worry about trying to argue that it's creating a nuisance or an unreasonable interference. Based on Artigue, occupiers will simply say, the smoke drift is causing a hazard to me. I don't need to put in any other medical evidence, because Artigue said there is sufficient medical evidence within the public domain to establish that secondhand smoke is a hazard. Therefore, orders will be made against the recalcitrant occupiers who are creating the smoke drift. Often I've been asked, well, where does it stop? Will it extend to vaping, for example? It will. It will extend to vaping where there is sufficient medical evidence in the public domain that secondhand vape smoke creates a hazard in a same or similar way to secondhand cigarette smoke. Someone asked me when I was previously giving a presentation on this topic, what about barbecue smoke? There's suggestions that barbecue smoke could be carcinogenic. If it is reasonably medically accepted that barbecue smoke is carcinogenic, then yes, that would appear to fall within the realms of a substance which creates a hazard, and therefore could become the subject of successful adjudication applications made by owners who are saying, or by occupiers who are saying that they're affected by barbecue smoke. So certainly fair to say that the Arctic decision has changed the landscape when it comes to how bodies corporate deal with secondhand smoke. For some time, and even prior to Arctic, we have, as a matter of course, been putting smoke drift bylaws in the same, adopting essentially the same wording as the one that was in Arctic. We do that as a matter of course, simply because smoke drift is an issue. It's a continually increasing issue amongst occupiers, and I suggest now that the Arctic decision has certainly given hope to those people that are, or say that they are affected by smoke drift. And as Matthew mentioned, we're happy to take questions if there are indeed any there.
Thank you very much, Mark. I think if anyone's got any questions, feel free to pop them in the Q&A. They can be on these topics, of course, or any other related topic while you've got people in the room prepared to answer them for you. I'm curious, Mark, that the bylaw that you mentioned in Arctic, I have had actually a couple of calls in the last few days from prospective clients of ours talking about, what would be different with BCsystems, that sort of discussion. And a few of them mentioned that they had wanted to change bylaws, but had been told by their current manager that it was prohibitively expensive and at least $5,000 to change a bylaw. So could you, if someone wanted to take away, look at the pet bylaw and the smoking bylaw, is that something that you'd recommend rather than, throwing all of the crayons out of the box and starting again? Should they just look at a couple of bylaws and get some, cheap advice on those and do it sort of piecemeal so that they're not opening a big can of worms?
Yeah, absolutely. If and we do it all the time, Matthew, where we get asked to not necessarily review a scheme's complete set of bylaws, but for example, with the smoke drift bylaw after the Arctic decision, we had many schemes come to us and say, we're quite happy with our bylaws. We don't want you to review them all. We simply want to include a smoke drift bylaw. Something like that is certainly not $5,000. Essentially, we prepare a motion which says, we change Schedule C of the currently recorded CMS to include a new bylaw to read as follows, and if the motion, and to then record a new CMS. Matthew, that might cost, it might take an hour or so. So on my hourly rate, say $550 plus GST. And then if the owners resolve to include that bylaw, then obviously a new CMS needs to be prepared and recorded. Whether we do that, whether the scheme does that themselves, that's up to the scheme. Generally, to prepare and record a new CMS is around the $1,100 plus GST mark, but certainly, yes, nowhere in the realms of the $5,000 you mentioned. That tends to be more where there's a full review of bylaws. You might be replacing bylaws 1 to 24 with bylaws 1 to 40. Even then, to be honest, Matthew, it's unusual to get to $5,000, I would have thought.
Yeah, I have had the experience before where, a committee wants to change one bylaw, then think, while we're at it, let's do a review. And it can become then a project that takes 2 years of consultation and, rounds of changes. And, as everyone on the call would know, it's usually impossible to keep everybody happy. So getting consensus on 25 different bylaws and the wording of those is really difficult. So it might be better to just do things a bit at a time and make some incremental changes and, have a lot of focus on that one bylaw, do a smoking project, review the bylaw, look at your signage, look at what people are doing down at the pool area and do them sort of one at a time and save a bit of money in the process. It just, you don't have to solve every problem on day one, right? So I think that's good.
Yeah,
a good suggestion.
Pick whichever mischief is causing the most angst in the scheme, and draft a bylaw around that. One thing I do always caution committees about is being too restrictive in the bylaws. And certainly that I've been involved with bodies corporate where the committee, through the, they've got good intentions, but they almost want to create the perfect scheme. And often you've got to say to those committees, you need to pull back because there's no way that the owners are going to vote to accept the bylaws that the committee might want to put forward to them.
That's good advice. We've got some questions in the chat. I said the Q&A before, but I think the chat button is actually where you pop those. There's a few in there. So we've got one from Andrew. It says about the pets. I don't understand how the legislation is trying to pressure landlords to be reasonable about pets, but the landlord can have the decision made for them by the bylaws, which are in conflict with the changes to the Act. I think that's just the crux of the tension, right? There's two different decision-making protocols, plus the various local councils have different rules about how many pets you can have and what type. I would say that the decision for a landlord, it's not made for them by the bylaws, because the bylaws are set by the body corporate and the landlord is a member of the body corporate. They might be a member of the committee, or they might just be a general lot owner. But if they don't like the bylaws in their own scheme, then they should do something about it and talk to the committee, put a motion forward to change the bylaws if they think it's too restrictive or too liberal. But you're right, that as I just said, you're not going to have everybody be happy. So there will be plenty of people who either want pets and the bylaws are too restrictive for their personal view, or they don't want pets and the bylaws aren't restrictive enough. The way that the government has gone about, or the Parliament's made these changes to the tenancy legislation, is really focused at giving tenants more rights, and it doesn't seem to give a lot of consideration at all to the body corporate. So the fact that the body corporate is mentioned in there, it's only got one mention, and it's only just in that list of grounds. It doesn't even have a paragraph about the impact on a body corporate. So it's really, they've made a change to affect probably a couple of million tenants, and in the process of that, they've affected lots of bodies corporate as well, but that probably wasn't their primary aim or their concern. And that'll be something to, have a good discussion about with your committee at the next committee meeting or AGM. Another question from Ariane, would you suggest we give our tenants a conditional yes to their pet request, but at the same time letting tenants know that keeping the pet is contingent on receiving written approval from the body corporate? Would landlords be acting within their rights and responsibilities if they did this, in terms of trying to think of ways to address the time frame lag? And the answer to that is yes, absolutely. Probably the worst thing a landlord could do is stay silent, because if you are silent, then you just totally forfeit the opportunity to set any expectations at all with the tenant. So if you receive an application for, just using a silly example, if you get an application for 5 dogs, you probably would just say no to that straight away. If you get an application for 1 dog and the bylaws say that all dogs need approval, then you probably should say to the tenant, yes, but on the condition that the body corporate gives its approval as well, and you can't bring the pet in until you get that body corporate approval. So you don't want to create a scenario where the body corporate says no, and then the tenant says, oh, but my landlord said yes. So it's really important to be really clear about what the bylaws are. If you can communicate that to the tenant with a screenshot of the bylaws and, some information, that'd be really helpful. Because if you give people, this is just a general, thing we observe in life. If you give people 2 answers and one of them they want to hear and the other one they don't, they'll probably have a tendency to just go with the answer they like. So you want to try and take the potential confusion out of it by just being really clear and specific. And if you're using a rental property manager, it'll be important for them to also be on board with you so that the messaging's consistent all the way through. We actually had this same seminar that we gave with the on-site caretakers for all of the BCsystems clients, and also any rental property managers who we have an interaction with in any of our schemes. And that was quite well attended, and it was along the same lines, and we gave them that advice that they need to know what the bylaws are before they answer the tenant, so that they're not giving the wrong information out by accident. Got a question for you, Mark, from Pitt. We've got very old bylaws and we are very keen to modernise and update. Can we change the smoking bylaw from a no mention of a bylaw to a no smoking bylaw? So it sounds like maybe they don't mention it at all at the moment, and they want to have a smoking bylaw.
Yeah, look, I don't, you certainly won't be able to just have a no smoking bylaw, because a complete prohibition offends the legislation, and that's why we're actually in the position we are with pets. So outright bans on behaviour have long been overturned by the Commissioner. So certainly, to answer your question, you can have a smoke drift bylaw, very similar to the one that we used in the for RT. And that will regulate smoke drift from common property. It certainly won't necessarily ban smoking within the lot, as I discussed. You can potentially ban smoking on the common property, and certainly within enclosed spaces by virtue of the other legislation I mentioned in my talk. Again, the procedure is simply the committee putting a motion to the owners in a general meeting agenda. And the owners will vote by special resolution to amend the bylaws to include a smoke drift bylaw, or not to amend the bylaws. I should also say, even though your bylaws are silent on smoke drift at the moment, you do of course have recourse to section 167 of the Body Corporate and Community Management Act, which picks up similar wording to what we used in the RT bylaw.
And so, Mark, that exists. The enforcement there is probably equivalent if the mention is in the legislation, but it potentially
that would be an adjudication application brought by the body corporate against the recalcitrant occupier, as opposed to a bylaw contravention notice being served.
But if it's something that's not in the bylaws, it doesn't have that ability to act as a deterrent for people to pick up and read under the heading of smoking.
100%, Matthew, because people aren't going to generally, other than people like myself, won't sit down and read 400 pages of legislation, but they might find time to read, 5 or 10 pages of bylaws.
Yeah. Got a question from that same Pit. What about new building apartments that ban smoking altogether?
Yeah, again, Pip, I'm concerned about blanket bans. I've certainly had some bodies corporate say to me they do want blanket bans on smoking, and indeed on pets. And of course, I've cautioned them against it on both counts, both smoking and pets. There's nothing worse, in my view, than having bylaws which committees know to be invalid included in your scheme, because you've then got this tension between a bylaw of the committee that knows to be invalid and what the adjudicator said in RT and the statutory regarding the statutory obligation on committees to enforce a bylaw. So, of course, it's very difficult to enforce an invalid bylaw. You might find that in doing so, you're expending a lot of money in the adjudicator's office, which ultimately the owners are going to be rather upset about if the adjudicator says this bylaw was invalid, and then the committee knew, in fact, that bylaw was invalid.
Mark, you made a comment before about the body corporate being able to ban smoking on common property. So like, pool areas, barbecue areas. I've actually had a building looking at taking away that ban specifically to try and fix smoke drift on balconies, because at the moment probably in most buildings, it is often banned on common property altogether. So the only place to smoke is in your own lot, or you've got to walk all the way out and stand on the street. So this particular building, instead of trying to, stamp it out altogether, changed tact and said, well, this little area of the common property down in the backyard, that's not near anything. We're going to make that the smoking area. So we're going to change the no smoking bylaw to say no smoking except in, this area. And we suggest everybody go down there because that way you're not bothering your neighbours. So I don't know whether that's worked yet or not, but that was probably an opposite approach to what a lot of people might think, because a lot of the, in apartment buildings it may not work so well, but a lot of our clients, certainly a lot of body corporate schemes in Queensland are big townhouse complexes, and they've got heaps of land around, and probably wouldn't bother people if they were 30 metres away from the house.
Yeah, and I always say, Matthew, and to our participants, smoke drift smoke drift itself is not simply a matter for community title schemes. I often give the example of houses perhaps in Paddington where they're cheek by jowl, and someone could be smoking in their kitchen and they have an open window, and the smoke drift causes their neighbour, who might also have an open window, to suffer. There is no law that governs that situation. So to a certain extent, community title schemes are in a better position because they can include bylaws that regulate smoking, whereas the neighbours at Paddington don't have any laws that assist them at all in that regard.
Yeah, good point. I think that's the end of our questions. Thank you again for everybody who attended, and thank you, Mark. We will send a survey around afterwards. We very much appreciate your feedback on how this went tonight and whether you found it easy and productive, and if you've got any other topic ideas. And otherwise, thank you very much and enjoy your evening.
Thank you, everyone.
Thank you.